Distinguished ladies and gentlemen, please, I want to welcome you all to this important event, which is the 2025 OLU SIMI National Moot Court competition. On behalf of the university management, and most especially the Faculty of Law, I want to welcome the distinguished dignitaries here seated at the high table, and especially our benefactor, and that is talking about Dr. OLU SIMI, the donor of the impressive Moot Court Faculty Resource Law Center. We welcome you, and we equally welcome your spouse. So before we start this event, I would like us to rise up for the national anthem, please.
Not only for us, but also people around the world. We shine the light of the knowledge gained. Oh, you grace, oh, you grace, born in all states and shining all the earth. We are the pride of the world today.
Thank you very much. Be seated, please. Good morning to you all, distinguished ladies and gentlemen. Like I said earlier on, it is my pleasure and privilege to welcome you all to this important event, which is the 2025 OLU SIMI National Moot Court competition. I want to welcome you all to this occasion. You will all recall that sometimes in 2023, at that other end on this campus and this complex, a dedication and groundbreaking and commissioning was done, and a magnificent and an iconic building was donated by a great alumnus of this university. And that is talking about Dr. OLU SIMI himself. And since that time, he has appealed that he wants a competition to be held annually. And the Moot Court competition is what we are doing, is opening ceremony. And this is the second of the series of that competition. We thank you, our donor. And on this note, let me quickly introduce members on the high table. We have here with us our distinguished council member, who is also a permanent secretary with the Ministry of Ministry of Education and Technology, and that is talking about our dear mom, Elijah Tosin Oloko. You are welcome, ma. Okay. Okay, thank you. Yeah, we don't have information. So you can see the filial relationship, and that is the main reason probably why she is here. Please, let's give her additional round of applause, please. We equally have with us here our Vice Chancellor. In fact, I'm really surprised that the Vice Chancellor is here with us. I was thinking that he is going to send a representative, because right now the AMPC is meeting, and which is one of the most important organ in this university. In fact, a critical, organ of this university. And decisions that will be taken today will affect the, virtually everybody in this university, because we are talking about the conditions of service. And I'm surprised that he's here. And that tells us that the importance that he attaches to this particular event and the respect and honor he has for the donor. So it is on this note that I want to welcome and introduce our amiable and workaholic Vice Chancellor, a distinguished scientist. In fact, he's a professor of cancer pathology. So let me introduce to you no other person than Professor Ayodeji Agbola. And of course, we have here with us our amiable university librarian. And library is the heart of the university. So we want to welcome you to our midst, Professor Feyintolani Tonifade. And of course, we have the host, the dean of that is our host today. He is our host, and it is to his credit that developmental events are taking place in this faculty. And it is on this note that I want to introduce to us the acting dean faculty of law, Dr. Gbade Akerimade. The people I will introduce now needs no introduction. But at the same time, I will just say some few things about them. Apart from the fact that Dr. and Mrs. Asekun are philanthropists, they are committed to the development of this university. Not that Dr. and Mrs. Asekun are so rich, but for the dedication and commitment they have for this faculty, that was why they were able to donate that edifice that we now call the Dr. OLU SIMI Law Resource Center. And I could recall that the day that dedication was being made, he had a kind of reminiscences about his time when he was in this faculty. He talked about the lack of infrastructure, especially when it comes to practical. No way to have demonstration for Moot court. So that is what actually propelled him, what actually motivated him and his family to bring out from the little they have and give it to this faculty of law, and by extension, Olabisi Onabanjo University. Please join me in welcoming Dr. and Mrs. OLU SIMI ASEKUN, our benefactor in this university. You are actually welcome, sirs. We love you, we like you, and we recognize your contributions to the development of the Faculty of Law. Thank you very much. I think I've done most of the introduction. I would like to introduce myself too, because some of you may not know me. My name is Niyo Duwale. I'm the Deputy Registrar Corporate Affairs and a Fellow of NIPR. And I want to welcome other distinguished faculty members of the Faculty of Law that are here with us. So as the event, proceeds, I will take more recognition. So that because the VC will soon be leaving, let us, fast forward most of these activities. So it is on this note that I will invite the Acting Dean of Law, Dr. Gbade Akinrinmade, to please quickly give his opening remarks.
Mr. Vice Chancellor, sir, Professor Ayodeji Agbola, our mom, sister, and aunt, who happens to also be a council member of the university and the permanent secretary, Ministry of Education and Technology, Alaja Oloko, management staffs herein present, my lords and worship, faculty members, participating teams, ladies and gentlemen. It is with great pride and pleasure that I welcome you all, especially our benefactor, Dr. OLU Asekun and his amiable wife, to the Asekun National Competition, built to run for the next 3 days with effect from today. This competition is the brainchild of Dr. OLU Asekun and his wife, through the OLU SIMI ASEKUN Incorporation. It is born out of necessity and expedience to fill one of the gaps in legal training identified by our benefactor when he was a student in this faculty. It is heartwarming that this gap is now one of the core curriculums for the training of lawyers in Nigeria. Today, we are gathered here to set in motion events that will make us witness the intellectual prowess and advocacy skills of our future young and talented participants from the following universities: Crescent University, Abeokuta, University of Lagos, Akoka, Adekunle Ajasin University, Akunba, Ondo State, Prince Audu Abubakar University, Ayingba, Olabisi Onabanjo University, Agowe, Fountain University, Osogbo, Elizade University, Laramokin in Osun State, and finally, University of Benin, Edo State. While the competition provides a platform for participants to engage in rigorous legal research, critical thinking, and effective communication, part of its underlying philosophy is to enhance the advocacy skill of our future promising legal practitioners. My elementary knowledge of jurisprudence still reminds me that judges are like still waters, and you have to teach them how to flow. In achieving this objective, the power of advocacy, which unfortunately is being whittled down with the introduction of written briefs virtually in all courts of record in Nigeria, is one of the arsenals which a practitioner must be endowed with. Permit me to share briefly an extract from Clarence Darrow's 7-hour closing defense argument in in Henry Sweet's trial for murder in April 1926. He was born on April 18, 1857 in Ohio. Clarence Darrow made his reputation as a defense lawyer, acting in some of the most notorious and high-profile cases in the U.S., including the Leopold Lee and Scopes Monterey trials. His courtroom oratory is demonstrated by his summing up in Henry Sweet's trial, has inspired generations of lawyers and many courtroom dramas. The background information and how did it happen? The growing car industry brought influx of black workers to Detroit in early 1926, and racial hatred was stirred up by the Ku Klux Klan rallies, with white mobs driving out black professionals living in largely white housing area and threatening others planning to move in. The night the Sweets moved into their home, an organized riot broke out, and rocks were thrown at the house. The Sweets reacted by firing from an upper floor, and Leon Brenner, a white man, was killed. The Sweets were tried for murder as a family and defended by Darrow. The jury failed to reach a verdict, and the defendants were released on bail. Darrow then defended Henry Sweet, who admitted firing a gun in the first of individual trials of each family member. Darrow believed that if we could secure an acquittal for Sweet, the case for the other trials would disappear. In his long summing up, Darrow demonstrated his superb qualities as a lawyer: immense courtroom skill, strong dramatic instincts, and powerful persuasive abilities. Darrow argued that the case was about racism, not murder. I insist there's nothing but prejudice in this case, that if it was reversed and 11 white men had shot and killed a black while protecting their home and their lives against a mob of blacks, nobody would have dreamed of having them indicted. Now, that is the case, gentlemen, and that is all there is to this case. Take the hatred away and you have nothing left. The jury took hours to reach a not guilty verdict, and in July 1926, the other defendants were dropped. Although the case ended in triumph for Darrow, the Sweet story is less happy. They returned to their home, but several family members, including Henry Sweet, died of tuberculosis within years of the trial, and his co-accused, Ocean, later took his own life. Permit me, in this regard, that I charge all the participants to seize this opportunity as the starting point of sharpening their advocacy skill, as we are all here to celebrate the support of legal education and intellectual discussion. While I wish all participants the very best in this competition, I once again, on behalf of OLU SIMI ASEKUN Foundation Incorporation, the management of the university, staff and faculty members, welcome you all to this second edition of this event. Thank you and God bless.
I think you can do better than that for your team. I would like to provide additional information, though the Dean has mentioned the finalists, the 8 universities that are now in the quarterfinals. But it may interest you to know that 21 universities picked from all the geopolitical geopolitical senatorial district of this country were selected. So we have 21 universities that actually started with this competition, this 2025, and they have now been reduced to 4, and those were the 4 that he mentioned. So you could, now know that this competition actually has a national outlook, and most likely we may progress it to international competition as time goes on. I think you should clap for the donor for that. I'm very sure the donor is very, very capable to do that. Let me quickly recognize one of the elders of this faculty. He was once a dean in this faculty, and he's a very good friend of mine, and that is talking about Professor Jason Oleide. Yeah, Prof, you are welcome into our midst. Nice to see you again. We have the judges for today's event as Mr. O.M. Shodende, Mrs. Kolawole Ogubowale, Mr. S.S. Shotayo, and Mrs. A.R. Afolabi. Please, we can do better than that. Let's give them a ovation. And of course, Dr. and Mrs. Olusegun Asekun did not come here alone. They are accompanied with some of their family members and friends. We have here Barrister Labi Okusanya. You are welcome, sir. Probably was one of the first to arrive at this event, because when I came in, I met him, running up and down, collaborating with the faculty members of them. You are welcome, sir. Of course, we have Barrister George Anibaiwe is here with us. Please, if I didn't get the pronunciation incorrect, forgive me, please. And of course, we have Barrister Sarah Brooks is here with us, all the way from Dallas. All the way from Dallas. Please, can you do a kind of clapping that they will hear? Let's at the airport, not at Dallas, but at the airport. So you are welcome here with us. And of course, we have testimony OLU Asekun, the beautiful daughter of the donor. Oh, you can stand up for recognition. Let's see you very well. Yeah, you can look back there, looking at you there. Yeah, that's fine. You are welcome. Yeah. So thank you very much, ladies and gentlemen. Now my pleasure to invite our Vice Chancellor to give the opening speech. Mr. Vice Chancellor, sir.
The principal officer of the university here present, the Asekun families, and by extension their friends and guests that are in with us, my dear colleagues in the Faculty of Law, and my dear students. I'm very sure that today is one of the best that we are looking for. A round of applause for ourselves. First, let me appreciate the Asekun family, because when I came in as Vice Chancellor, I have 3 pillars that I'm pushing for all my students to have. And I call the 3 pillars 3 E's. I want my students to be able to further their education. I want them to be an employer of labor, and I also want them to be employable. And there's no way you can do this alone. We want, I need support of everybody to be able to carry that goal across. Fine, my colleagues are doing well, they treat them well, but we need the practical knowledge of what is actually going on in the society. Because if you are going to be employable, they need to know what they are doing, where they want them to be employed. If they're also going to be a employer of labor, they themselves must also have the knowledge of how to employ people, which is the entrepreneurship component of the work. And behold, the Moot course shows clearly if we are going to go far in law, you must know how to argue your case well. And the basic knowledge I have in law, by sitting down and interacting with my colleagues, also helped me a lot in the administration of the university. I keep on saying it as Senate of the university. Anytime I sit down with the lawyers, they will tell you, no, you can win this case if you have these three: the facts, the evidence, and the law. And they will say, oh, they ask them, who provide the facts? So you are the client who provide the facts for us. So if you are going to get the money from me, but I'm going to give you the facts that I'm going to use. Then the second one is, who provide the evidence? You are also the one to provide the evidences that I'm going to use for you. The only one I'm going to do is to find the law. And since I know that that is what they do, it's also helped me in the administration of the university. So when I go to Senate, the first thing I try to do is to study those papers very well. And those papers are just the facts of the case. And when I study them, I ask Senate office and the registrar, can you provide the evidences of all this thing that you give to me? So that when you have that, I can then go to the edict of the university and support it with the law. And so when I go to that place, I try, even the one that is not in the edict of the university, but we have judicial notice. I'll quote those judicial notice that is also relevant to what I'm talking about. Can you see that the law has also helped me to manage the university very well? Another applause for me too now. And behold, as soon as the Asekun family instituted this competition and have that building, I approached the attendant and I said, we have done one out of the three that I'm looking for. I'm looking for somebody that can bring about the entrepreneurship component. Oh, he said, I have somebody in mind. And I said, who is that person? He gave me the name of October Femi Okela. And I said, then you will approach that individual yourself and be able to discuss extensively what I also have in mind. And truly, the man accepted to give us the entrepreneurship component of this work. On June 4, to be precise, we'll be commissioning Okela Entrepreneurship Center, which is the second one. Station, when people saw those things going on, Alhaji Fago approached me. He said, he saw Asekun Resource Center there. And I said, oh, he's one of us. He's also an alumnus of this university. And he said, I can see that Okela did the foundation there. I said, we also say the same thing. It's also one of us. He then asked me, what do you want? I said, well, there's also one component that I also need. Because if my students, if I have 750 students in a class, and I don't have a 750 seater hall for that faculty, then it doesn't make sense. There's no way the student can sit down and take that lecture. Then he asked me, is that all? I said, for now. He said, okay, do you have a parcel of land where I can do that? In this university, I have 33,000 hectares of land. I said, okay, can we go there? I said, let's go. And then all the meetings I was having, I suspended the meeting immediately. I said, let's go there. So we got there, the man said, where? I said, this place. You can take everywhere here. Behold, we are going to write an exam in that 750 seater hall. What it implies is that Faculty of Law has always a trailblazer in this university. The alumni that all the faculty are now putting together started actively at the Faculty of Law. In fact, I kept on saying it to my colleagues in medical school. They said we only put name on their heads. Go to Faculty of Law, they will teach you how to do it there. Because there was the last accreditation, we brought seats to this faculty. And then the dean told me, Sir Vice Chancellor, we don't use this kind of, our students don't use this kind of seat here. We do respect. We can take it to where they need them. And they provided the seats for the students. If we go around, only a few places you see this kind of seats that they make use of. If we enter that place, it's also not the same. So you give them a round of applause. They have been doing excellently well for this university. And therefore, I'm not surprised that when they go to law school, they are always one of the best there. I think the last time the dean told me, is it 17 now? 14 here. So they have 14 class there. 14 first class. So it's so that we can compete favorably with our peers anywhere in the world. And I want to thank my colleagues, the students, for keeping the pace and making the university proud. And it's because they are making it proud that the Asekun family can also be happy, because if what the man has been doing here is not translated to physical and manifestation in the lives of all these students, he will be discouraged and the family will also be discouraged. I know for sure that so many people are now coming to the university to assist us in achieving this goal. And every day, I raise my shoulder anywhere I go, and that this is OLU, I'm one of them. And if you look at that anthem very well, if you look at the last sentence there, we're in Ogun State, born in Ogun State, but shine all over the world. And that's why I always end my speech anywhere I go, and it's for my students, and they know the song they've said. Àtìgbà táláyé ti dáyé, kò sọ́mọ OLU tó ṣorí burúkú. Just will not be an exception. I know we will always be there. Keep doing the best, and OLU shall always be on top. Thank you very much for listening.
That was a very beautiful speech. Let me tell you some facts, though I may not be able to bring out evidence. It is a fact that our Vice Chancellor is an alumnus of this university, just like Dr. Asekun. It is also a fact that the Vice Chancellor is a medical doctor. And it is also a fact that the Vice Chancellor is equally a seasoned administrator at the highest level. And he has just revealed to us that he uses two major tools of law in his administration, and that is talking about facts and evidence, isn't it? Based on the following premises that I've established, I think we can confirm on him that he is a professor of clinical law. You know, medicine and law, he has combined both. So he's a professor of clinical law. Mr. Vice Chancellor, you are welcome, sir. Please, we are going to move to the next item, and we want to hear from our donor and our sponsor, our benefactor, and that is talking about our illustrious alumnus, Dr. OLU SIMI ASEKUN. He is going to talk with us now, so we are going to listen to his speech. Doctor, you will stand there, sir. Your citation because your citation will be read by Mrs. Adeyemi Balogun. Where is she?
The Vice Chancellor of this Citadel of Learning and the principal members of our great institution, members of our amiable members of Faculty of Law, my Lord, as represented by His Worships, the great students of OLU, our donor, as we can see, is so rich in everything, as endowed in him by the Almighty God. We thank God for you, sir, and the entire family. I will say thank you, sir. I read the profile of Dr. OLU SIMI ASEKUN. The Yorubas will say, Orúkọ náà fi ń pọ̀ bá aládé. Permit me to call you by your name, sir. Dr. OLU SIMI ASEKUN, the chairman BOT, OLU SIMI ASEKUN Foundation Incorporation. Dr. OLU SIMI ASEKUN is a renowned legal luminary and philanthropist who has dedicated his life to promoting legal excellence and access to justice. His commitment to the development of young legal professionals is evident in his support for the Moot Court, the National Moot Court competition. Dr. OLU SIMI started his legal career in 1994 when, together with his bosom friends, Barrister Femi Ogunbanwo, who is popularly known as Omoiwa, and Barrister Labi Okusonya, our co-hosts, they all together established Ogunbanwo, Asekun, Ogunsonya, and Co. in Lagos, Nigeria. He subsequently, that is our sponsor today, our benefactor today, Dr. OLU SIMI. He subsequently relocated to the United States in 2002 with his lovely wife, Simisola. And armed with the rugged training received from this, our Citadel of Learning, it was Osuden, and now it's all. It's all OLU. As the Vice Chancellor has rightly said, kò sọ́mọ OLU tó ṣorí burúkú. I am an epitome, so I'm an example. I'm sorry. So they both relocated to the United States. And with his training that had already been received, he dusted all the exams he took. Please, can you applaud? Yes. He took the New York bar exam 3 months after getting to the US and passed it at first attempt. A round of applause for him. Immediately within the same year, 2002, as the founding partner, established the law office of OLU SIMI PC, located in Arlington, Texas. He subsequently obtained a doctorate degree in transformational leadership. He is licensed by 1. Nigerian Supreme Court, United States Supreme Court, New York Supreme Court, and Texas Supreme Court. Our donor, as handsome and brilliant as he is, he's a member of the following. He's a member of the New York State Bar Association, Texas Bar Association, American Bar Association, American Immigration Lawyers Association, Nigerian American Lawyers Association, Nigerian Bar Association, and and is also an accomplished author. He has authored so many books, amongst of which I just want to mention few. One, by him, OLU SIMI ASEKUN, American Immigration Questions and Answers. Paradigm House, December, it was published in 2017, December. Another one, a handbook for aliens to remain legal in the United States. It was published by Author House in 2005. Another one is God versus Science. It's also a book. My Testimony, True Life Story. It was published by the same Author House in 2005. Another one is OLU ASEKUN Prayer Vitamins. The vitamins, essential nutrients for spiritual growth. It was also published by Author House in December 2006. There's another one by him, Destiny. A memoir, the true life story of the dangers of writing of a child. We must not write of any child. It was published by Cedar House in June 2023. Our donor, our benefactor, has successfully handled very complex and complicated immigration cases across the United States. Citizenship and immigration, he is a passionate litigant who is a passionate litigator who has won multiple cases against United States. Citizenship and immigration services at the federal courts and courts of appeals, setting precedents along the line. Dr. OLU ASEKUN has a YouTube channel where he discusses and answers immigration questions in his weekly podcast every Wednesday at 12 p.m. Central Standard Time, CST. I humbly introduce our donor, our handsome and intelligent and brilliant, the handsome and the brilliant donor, our benefactor, Dr. OLU ASEKUN. Welcome, sir.
The Vice Chancellor, sir, the Permanent Secretary, the Dean of Law, all the professors around, your worships, and of course my guest from Dallas, the students. I hope I didn't miss anyone, but all protocols observed. Thank you again for participating in today's event. Actually, I was informed just recently that I'll be talking briefly about the benefits of having moot court. It's a very difficult thing to hand a microphone to a lawyer to expect him to talk about that kind of topic in 5 minutes. I understand that the VC has time constraint, so I'm going to try my best. Just give me 2 minutes. I promise I'll be very, very brief. You see, there are so many benefits of having a moot court. Even the VC, without being a lawyer, has actually touched on some of them. The most important one is the bridging of gap between theory and practical. That was what we missed during my own time, because we didn't have the beautiful opportunities that you students of today have. I was showing my daughter the campus that we attended. We didn't even attend this campus because this campus was not in existence at the time. But the point I'm making here is that the bridge between theory and practical is actually one of the fundamental benefits of having a moot court competition. Because what that does is that it helps students in three things that can actually lead any lawyer to become a successful practitioner. What are those three things? Legal research. Of course, there's no way somebody will go into a competition and not conduct research. So it's going to sharpen the student's ability to conduct legal research. The second thing is the oratory skill. You see, for somebody like me, I am a very practical person. I didn't have a lot, well, I had the opportunity, but I threw it out. I threw it away. Because many people will not even believe today that when I was in secondary school, or what we call high school in the US, I didn't take literature as a course. So you'll be wondering how I managed to become a lawyer without taking literature. Not that they were not studying literature in my school, but because I was not staying in class. So as soon as the literature teacher comes in, I leave the class. But that missing link, everything that I lost, I regained when I started moot court competition. I regained it, that oratory skill. Just like the Dean articulated when he was talking, when he was giving his own speech. You see, when you see a lawyer in court, one of the best things that can make you win a case is your oratory skill. I have Mr. Anibowe here sitting down here. He's my colleague from Dallas. I remember, he may not even remember what I'm about to say. He once had a client. They were going to have a trial at the immigration court, and he needed to travel out of the country. So he told the client that, look, one of my friends is going to handle the case. The client said, no, it has to be you or nobody else. No. But he had to travel. So he insisted. The client was not happy, but he insisted. So he gave the case to me. I went to court. After I finished making my argument, I didn't even know this. He was the one that told me after. The client called him over the phone. Were you in Nigeria at the time? The client called him over the phone that, look, even if I lost this case, I'm satisfied that the performance of that lawyer in court today, that nothing else. But guess what? The defense, the government, they couldn't defend my position. So they had to drop the case. So what am I saying here? The benefit of having a moot court competition, I'm going to sum it up because I don't want to waste a lot of time. As I said, as a lawyer, I can talk for hours. But I'm going to sum it up with what legendary Cicero, one of the Italian philosophers, what he said. He said, the study of law renders man acute, dexterous, eloquent, inquisitive, prompt in attack, ready in defense, and full of resources. All these sum up the benefit of having a moot court competition. God bless you.
I think we can do better, please. Yeah, thank you very much, sir. And we don't want to waste our time. But when our donor was giving his brief speech. We have one of our faculty advisory members that came in person of Chief Wale Taiwo, SAN. We welcome you. That's not a clap for SAN. Senior Advocate of Nigeria. You are welcome, sir. Thank you very much. Now, the organizers have informed me that we are now going to take the citation of Mrs. Asekun too. So I will want to invite you, madam, to please come forward and stand there. It's a case of what God has joined together, let no man put asunder. And to read that citation is Dr. Fumi Olabode. Dr. Fumi Olabode
and the principal officers of this great university, the sponsors of today's program, the Dean of the Faculty of Law and other distinguished members of the faculty, our invited guests, and greatest OUites. Mrs. Simisola Asekun attended Obafemi Awolowo University, where she studied international relations before relocating with her husband to the United States. She subsequently changed her career to nursing. She obtained bachelor and master's degree in nursing. She's currently an advanced practice psychiatric and mental health nurse practitioner. A round of applause, please. She is the CEO of Transcend Mental Health and Wellness Clinic, located in Arlington, Texas. She specializes in providing holistic mental health care, helping clients achieve balance and well-being through personalized treatment plans and innovative therapeutic techniques. Together, Dr. Olusegun and Mrs. Simisola Asekun have made a significant contribution to the legal community and beyond, both in Nigeria and in the diaspora. And we are honored to have them as our sponsors. Their support has enabled us to bring together some of the brightest legal minds in Nigeria. And we are grateful for their trust in us to bring this mission home. Thank you for that.
Please, we can do better. Okay, thank you very much. When Madam's citation was being read, I was thinking that I had, like, she attended OLU, but I tried, I said I was thinking, maybe you people are lawyers. You allow me to present what I'm saying now. I said I was thinking, and I quickly confirmed, and I was told that it was OAU, the Great Ife, and this is the greatest. OAU is the greatest. What I had actually wanted to do, if it has been confirmed, but it wasn't confirmed, and I have no evidence. And it is clear now that she attended OAU. If they have said that she attended OOU, Dr. Shegun Asekun, I could have asked you that, what were you doing while you were here? But thank God that you were focused while you were here. Please come. Yes. I think Peter Esquire is here. We will ask him later. Thank you, sir. Now, this thing is in form of a tripod. And The third leg of it is the foundation. So we are now going to read the citation on the foundation. And to read that, I am told, is Mr. Bola Odeyale. While the foundation will be read, I will ask members that constitute the foundation to remain standing wherever they are, please. The foundation members, wherever you are, yes, the BOT, please. Members of the BOT, you stand up wherever you are and you remain standing there.
Thank you, sir. The Vice Chancellor and all the council member present, the Dean, Faculty of Law, OLU Olombanjo, please permit me to stand on the existing protocol. About the OLU Asekun National Moot Court Competition. Dr. OLU Asekun and Mrs. Simisola Asekun, via the OLU and SIMI Asekun Foundation, are the donors of the great edifice known as OLU Asekun Law Resource Center, which sits majestically at the Faculty of Law, Olabisi Onabanjo University. The OLU and SIMI Asekun Foundation is also the sponsor of OLU Asekun National Moot Court Competition. The maiden edition of the competition was held between Thursday 13th and Friday 14th June 2024. 8 Faculty of Law across the Southwest competed, and it was a huge success. This is the second edition of OLU Asekun National Moot Court Competition, a bigger and better edition. The second edition holds for 3 days between Monday 2nd and Wednesday 4th June 2025. About the sponsor, OLU Asekun and SIMI Asekun Foundation Incorporation. OLU and SIMI Asekun Foundation is a non-profit, non-political organization duly incorporated by the Corporate Affairs Commission on the 10th day of August 2023 with registration number 7091157. The foundation was conceived, promoted, and founded by Dr. OLU Asekun, PhD, an alumnus of Ogun State University, now Olabisi Onabanjo University, with the unwavering support of his wife, Simisola Asekun, an alumna of Obafemi Awolowo University. The establishment of the foundation fulfills Dr. Asekun's long-standing vision to give back to his alma mater and to meaningfully advance the development of legal education in Nigeria, particularly at the foundation level. Objective of the foundation includes, among so many, supporting the education and training of indigent, underprivileged, and vulnerable individuals in the society. Number 2, promoting and enhancing access to quality legal education in Nigeria. 3, establishing a resource center dedicated to the development of quality human capital in Nigeria. The foundation has the following as its trustees. Number 1, Dr. OLU Asekun being the chairman, Mrs. Simisola Asekun, Otunba Labi Ogusoya, Mr. Olakunle Rufai, Professor Charles Adekoya, and Pastor Toye Oshungbeson. In addition to all I've read, Dr. Asekun, Olusegun Asekun, clocked 60 last month, being 7th day of May 2025. Thank you.
Thank you very much. Leveraging, you can be seated, please. Leveraging on the last sentence of the person that read the citation of the foundation, and he said Dr. Segun Asekun clocked 60 just last month, and I've been reliably informed that the faculty will want to celebrate him, and it is on this note that we have that beautiful cake. I will invite members that are at the high table to be there, and his family to them. Please let me hand over the mic to Dr. Kolawole, who will anchor the procedure.
Thank you, Your Sister. Good afternoon, the chairman of the occasion, the principal members, our sponsors, the dean, our invited guests, and my colleagues, the students, especially the pastoral students, and the jurists. We thank you for coming. Today, we want to commemorate the birthday of our sponsor, Dr. OLU SIMI ASEKUN, and have this small cake. His intention that we want him to know that, yes, we identify with you. I informed him earlier on that we are going to sing the happy birthday song for him in Ijebu language. And then I'm sure that he will be curious to know what that song is. It's a traditional Ijebu song that goes like this. Oníbàìdé kò ní kú, oníbàìdé kò ní rùn, owó tuntun á wọlé, ọmọ tuntun á wọlé, Olúwa ló máa ṣàgbéyìnde, owó á wọlé rẹ, ọmọ á wọlé rẹ. Ohun mẹ́ta lẹ̀dá ń wá, ẹ̀dá ń wọ́wọ́, ẹ̀dá ń wọ́mọ, ẹ̀dá ń wá láyé. Eré ò là ń fọmọ ayò ó ṣe, Olúṣẹ́gun dọmọ ayò ó, eré ò là ń fọmọ ayò ó ṣe, aya rẹ̀ dọmọ ayò ó, eré ò là ń fọmọ ayò ó ṣe, ọmọ rẹ̀ dọmọ ayò ó, eré ò là ń fọmọ ayò ó ṣe. For he is a jolly good fellow, for he is a jolly good fellow, for he is a jolly good fellow. Goes those for any rere wọ́n jẹ́ o, for any rere wọ́n jẹ́ o, for any rere wọ́n jẹ́ o. Dédé ni re sọ wá, dédé ni re sọ wá, múso, dédé ni re sọ wá, múso. For any rere wọ́n jẹ́ o, for any rere wọ́n jẹ́ o, for any rere wọ́n jẹ́ o. Dédé ni re sọ wá. I'm sure we have loved the Gen Z and the Alpha generation, so let's sing the traditional happy birthday song as it moves to the cake, together with the principal members to cut the cake. Let's say happy birthday to you, happy birthday to you.
Happy birthday to you. Happy birthday to you. May the good Lord bless you. May the good Lord bless you. May the good Lord bless you.
All of us will put our hand up. Work for it together. Sorry.
Okay, what about the daughter? How was she doing? Okay.
Yes, it's fine, it's fine.
Okay.
What we need is
Just come to town. Wow. Wait,
Happy birthday to you. Happy birthday, happy birthday, happy birthday to you.
That I could see in our midst a business guru, is a businessman, and I'm very sure he must be a friend of the Ashekuns, and by extension a friend of the faculty. He's equally my friend, and that is talking about Alhaji Rabi. I want to welcome you to our midst, sir. You are welcome. Mrs. Kolawole, please. Dr. A.K. Kolawole, please. Dr. Kolawole happened to be the secretary of the LOC. He is going to do the presentation of participating teams. Please, can we give her a round of applause?
And I want to say welcome once again. We have 8 participating teams, or let me say we had, that qualified out of a rigorous intellectual contest. 8 were chosen to come for the quarterfinals, which we later moved to 4 teams for the semi-finals. The 8 are as follows. Team Elizade. The coach is Dr. Adeomi Taiyewo. Please, can you just stand up as you call your name? Thank you very much for coming. And the members are Oluwakemi Sola Oladileji. Then we have Oluwaseun Fatudi. Thank you for coming. Then we have Team Crescent, and the coach is Adeyemi Justus. Is he here? All right. And then we have Ologun Oyindamola. Thank you very much. And also we have Mujib Imran. Mujib Imran? Thank you. All right. Then the next is Team Unilag, and that is the coach is Ayotunde Abiodun. All right. And we have Adedayo Michael as a member of the team. We also have Precious Amike. Then Team Kogi, all the way from Ayimba. I happen to have undergone my youth service 1990 in Ida, which is now part of Kogi State. Then it was under Benue State. So I still can speak a few words. Only that I'm sure that these are Gen Z people. They might not even know the meaning of all Odudu. What's the meaning? I'm sure they will know. So the team coach could not join us, but we have Jacob Ujima Fidelis. Then we have Omede Miriam Enojo. Thank you. Then Team Uniben. I'm sure Mr. George Anibo will be so pleased to see. I'm sure he has met them this morning. And we have the coach as of KP Odudu. Then we also have Ofe Oluwajoda. We have Osawi Abonwanete. Thank you for coming. Then we have Team OLU. The coach is Oluwaseun Ogunaike. We have Dele Ogundijo. Then Odukoya Ayobami. Adeha is not here. I'm going to step out. Then Team Akuba. Akuba is also so far away from us, but they were here last year, and I'm so happy that they are here again. The coach is Olukoju Peace. We have Olukayode Paul and Ajayi Temiloluwa. So the sessions will be holding immediately after this opening ceremony. Thank you very much. We appreciate you. Thank you.
The end of the program, and that is the closing remarks, stroke vote of thanks, an announcement by Dr. A.O. Salau. Immediately after this, we are going to have a group photograph. Immediately after this, there will be a group photograph. Here, we will all find here, down here, to be joined by family members in 2 sessions the family, then later the faculties, then the third one will be the students. Thank you very much. Dr. Oshinobi will be will be giving the vote of thanks. Dr. Oshinobi, please.
The Vice Chancellor, in absentia, the Dean of Law, our distinguished sponsors and benefactors, the celebrants of today, learned professors and members of the Faculty of Law, members of the Board of Trustees of the OLU SIMI ASEKUN Foundation, presiding judges of the Moot Court, our learned worships, our invited guests from within and outside the shores of Nigeria, from US, from all over the world, colleagues from other universities, and members of the university community, greatest OUites, greatest OUites, greatest of the greatest OUites. Before I give the vote of thanks, I also want to recognize the impact of what Dr. Ashegun has done. And it's encapsulated by a quotation which states that great leaders do not merely see the world as it is. They envision what it could become. They are architects of the unseen, building bridges where others see void. They inspire movement long before the road is clear. Their strength lies not in just in seeing further, but in awakening the eyes of others to the possibilities yet to be born. And this encapsulates what Dr. Ashegun has done here. Even before anybody thought of the Moot Court or helping out the students, he had a vision and he brought his vision to life. And that is why we are all here today. We were here last year. I was here during the turning of the soil. Some years ago, I was here during the first Moot competition. This is the second one. And by the grace of God, we will all be here next year and in subsequent competitions. So on behalf of the Faculty of Law and the university, I want to say a big thank you, sir and ma, our great benefactors. In fact, the greatest benefactors in the history of the faculty so far. We can't find the right words to thank you enough, but we just say a big thank you. We appreciate you tremendously. And other members of the faculty, thank you for the cooperation in putting together this program. Our invited guests from other universities, thank you for making the trip to Agorwe. We appreciate your presence. We appreciate everybody for coming. I also have to thank the coordinators of the program, Dr. Eo Salao, Dr. Kola Wale, Dr. Ayonleye, everybody. That's been, it takes a lot of effort to put this kind of program together. And we appreciate all the efforts. We appreciate our students too, who are here. And finally, we thank God for making this event possible today. And well, I wish everybody a wonderful time in the next 3 days, all during the competition, and may the best team win. Thank you very much.
Yes, I think we are now at the end of the program. Next on the program of event is the group photograph. Please let us remain standing. The group photograph will be conducted in this order. Our benefactor, Dr. OLU SIMI and his wife, and the faculty members, then the students. I want to introduce to you our mama in the Faculty of Law, She stepped in while we are about rounding up. She is Professor Moji Ogungbe. Mojisola Ogungbe. Please, a round of applause for our mama. We are glad to have you in our midst. Thank you very much and God bless you, ma'am. After that photograph by our benefactors, their family members should join. Thank you very much. The family members, please. Let's have the faculty members. The faculty members. This our dean will be.
Happy birthday to you.
Thank you very much. Let's have the students.
Happy birthday, happy birthday, happy birthday to you. Happy birthday to you. Happy birthday to you. Happy birthday, happy birthday, happy birthday to you. Happy birthday to you. Happy birthday to you. Happy birthday, happy birthday, happy birthday to you. Happy birthday to you. Happy birthday to you. Happy birthday, happy birthday, happy birthday to you.
Yes, we said. Yes, I know. Served when?
You were served on the person who came to the
You were served or you served the other person?
You served the other person, let's say.
Yes. Was it good for? Have you been served?
My Lord, strictly sense, we have not been served in the moment. Although we didn't actually before the council, the duty submitted to the local organizing committee, but we didn't get the memorial.
So if you have not been served, how do you respond to sin?
My Lord, that we have the solution and we have the body to do the young things out to
During the address, you fought for the defendant, then how did you respond when you were not served? Yes. Yes. Can you move now?
What's up, guys, my Lord? My Lord, before I proceed, don't waste time on this honorable report, my Lord. I would like to state some of my grievances as regards the evidence found.
Moment. Yes.
My Lord, this is a general objection, my Lord. I see the judges of this court state my grievances, why
you have primary objection.
Yes, my lord.
Yes, that's not grievances. You have issues that you want to raise. You do not express your grievances before the court. Yes. Yes, what's your PO?
My lord, my counsel, my letter colleagues here, signature was left at the door, not like the validity of their document, my lord. It's a common knowledge that on signed documents, my lord, it appears that my letter colleague signature was left at the door, much like the validity of their documents. My lord,
what document are you referring to?
The documents, the whole document is served us. The process is served us as at 30th and then June 1st, my lord.
Was not said, was not signed.
Well, yes, my lord. It was not properly signed, it was not properly dated. And we were meant
Not signed is different from not properly signed.
It was not signed, my lord. It was not signed and it was not dated, my lord.
What was not dated?
All the evidence, my lord. Evidence that was sent to us.
What we have before the court are all signed.
My lord, this was the evidence they served us as at June 1st.
As what? As what?
As evidence to this case, my lord. None of this was signed. Nor was it dated. And the public documents here, my lord, does not have, is not certified to copy, my lord.
Counsel?
Yes, my lord.
Let's leave the realm of technicalities. All the documents before the court are all signed.
As it all cases.
Yes, can you proceed now to the merit of the case?
Most of my lord. My lord, the defense has drafted 3 cases for examination, my lord. The defense has drafted 3 issues for examination, my lord. Why are we deliberating?
You have raised 3 issues for determination.
Yes, my lord. Why are we deliberating on issue 1 and 2, my lord? My co-pastor here will be dissecting the issue 3 and prayer, my lord. May I proceed, my lord?
Yes.
Most obliged. My lord, the question of issue 1 is question on the constitutional foundation, my lord.
Your enumeration is not contained in the brief you said you filed.
It is, my lord.
What paragraph?
Page 3, my lord.
Yes.
After the judgment of law, we have to do that, my lord.
Yes.
May I proceed, my lord?
Proceed.
Most obliged, my lord. The question of issue 1 further the constitutional foundation, my lord. It is raised that there is an allegation against the parent of my client here and on his failure to declare his assets and the use of foreign accounts, my lord, during his tenure in the office. My lord, to properly elaborate this issue to the proper understanding of this court, I would like to vehemently advance my point from 2 major standpoints. 1, that Chief Arrest declared non-declaration of assets constitutes constitutional violation. And if Chief Arrest truly maintained and operated a foreign account while he was in
You
office.
refer to the chief as the defendant before the court.
Alright, my lord. I apologize for that, my lord. To the very first germane question, the defendant argues that he followed due process in compliance with section 15 of the Code of Conduct, Bureau and Tribunal Act, and the third schedule of the Constitution of Federal Republic of Nigeria, 1999 as amended.
Do you have the law you just referred the court to?
What?
Do you have the law you just referred the court to?
Yes, my lord.
Yes.
Section
Do you have the law with you?
No, my lord. I have the e-copy, my lord.
Yes. That's the law. The court recognizes that too. Yes.
My lord, do you want me to present the e-copy to the court?
You do not address the law as you.
I apologize, my lord.
Yes.
My lord, section 15 of the Code of Conduct, Bureau and Tribunal Act, and the third schedule of the Constitution of Federal Republic of Nigeria, 1999 as amended. a foreign account. My Lord, the provision of the Code of Conduct Bureau and Tribunal Act requires all public officers, which in this case is the President, to declare all assets owned by them upon assumption of office and after their tenure, my Lord. Without undermining the framework of this act, it is fundamental to note that this act made provision for the penalties of non-submission, however, failed to make a provision for the offences of late submission, my Lord. However, this is judicially baptized by a learned brother, Justice Dama Dikuma, in the case of Code of Conduct Tribunal against S. Udiekashila, my Lord. Citation to be provided in footnote 4 of page 5, my Lord. My Lord, it was stated in this case that the defendants would be unjustly punished if they were penalized for late submission. My Lord, the learned justice ruled in favor of the defendants on the grounds that the Code of Conduct Bureau erred in law for refusing to acknowledge the faults of the councillors based on late submission.
Refer the court to that case law.
My Lord, the citation is provided. It's not my doing against that. I have the report.
So you cannot refer the court to the law report that is not before you.
My Lord, this case was not provided in any law report, my Lord. The CCT, the Code of Conduct Tribunal have not published most of their cases. These cases and their facts were gotten from news outlets and reporters, my Lord.
Record, right?
May I receive, my Lord?
You got it online.
Yes, my Lord.
Verify the source.
Yes, my Lord.
Refer the court to that source.
My Lord, Vanguard News, my Lord.
Vanguard News.
Yes, my Lord.
Yes, continue.
Most of that, my Lord. My Lord, in this present proceedings, the defendant vehemently argues that although he is guilty of late submission, however, he is not guilty of non-submission, my Lord. My Lord, while he failed to submit this form at the stipulated time by the Code of Conduct Tribunal, he took a broad step to carry out this duty. He wrote a formal apology letter alongside this supposed form to the Bureau when he wanted to submit. My Lord, evidence as to this was have been duly provided. My Lord, the Bureau never accepted this form and apology letter due to late submission. However, at the end of his tenure, he made another submission, fulfilling the requirements of the Act, my Lord. This submission was made through a website owned by the CCB, my Lord, and the confirmation mail was sent to the defendant's mail account. Evidence as to this was has been duly provided, my Lord. My Lord, the defendant claims that the special investigative panel has not diligently carried out the duty required of them. On this note, the defendant asserts that the panel is biased because he was never interrogated, not summoned for questioning. My Lord, this has not only portrayed lack of procedural fairness, but also an infringement of his rights of fair hearing. My Lord, upon all arguments canvassed above, the defendant respectfully submits that all allegations raised against him as regards his failure to submit the declaration of form or the declaration of assets form is untrue, my Lord. My Lord, I would like to move on to the second standpoint of issue 1, my Lord.
Did you consider section 15 sub 1C
of the Code of Conduct Act, my Lord?
Yes.
Yes, my Lord. I mentioned it earlier. fraudulent diversion of public funds, my lord. However, again, this act has not made express provision as to the effect of owning a foreign account before assumption of office, my lord. Herein, the prosecutor has done a great job discovering the foreign account of Chief Arrest. However, they have not been able to establish its operation during his term in office, my lord. Thus, they have failed woefully as proving the maintenance and operation of the account during his tenure. My lord, as you may consider to the fact that the defendant's action amounts to constitutional violation, the defendant contends that this court lacks jurisdiction on this issue. My lord, on this issue, as any matter of such should be treated in Code of Conduct Tribunal, and if need be, should be further argued to the Court of Appeal, my lord. The tribunal has the power to try certain matters that border on corruption of public officers, which includes collecting bribes and use of unauthorized use. These are not my words, my lord, but the words of your learned brother, my lord, Justice Dr. Sama, in the case of Federal Republic of Nigeria against Bukola Saraki. Yes, my lord.
So consider section 23C of the Code of Conduct and Tribunal Act before you proceed. We are challenging the jurisdiction of the court, still must be trashed out before we proceed. But look at that section in this court and still hear that this matter.
Yes, my lord. Section 23C of the Code of Conduct Review and Tribunal. 23C.
23(6).
6.
Yes.
My lord, Section 23(6) of the Code of Conduct Review and Tribunal Act states that punishment under this section does not prevent a public officer from being prosecuted or punished for an offense.
Where are you reading from? Code of Conduct Review and Tribunal Act.
Yes, my lord.
Section 23, sub 6.
Yes, my lord.
Yes.
It states that punishment under this section does not prevent a public officer from being prosecuted or punished for an offense in a court of law.
What because nothing in this section shall penalize the prosecution of a public officer punished under this section, or preclude such officer from being prosecuted or punished for an offense in a court of law. Is this a court of law?
Yes, my lord.
And this court prosecute or advocate over it?
My lord, I'm not trying to teach my lord the law, my lord. However, this has to do with the punishment of a public officer. But this case has to do with corruption cases, my lord.
Yes.
And it has been duly stated by learned Justice Walter Samuel in Federal Republic of Nigeria against Bukola Saraki that any issue as regards corruption of public officer is treated in the Code of Conduct Tribunal, my lord.
Continue.
Most obliged, my lord. Humbly, my lord, I would like to refer this case to the landmark case of Moot and others against Iketlin and others on the importance of jurisdiction in any case, my lord. Therefore, the defendant solicits that the issue
What is the citation of that case?
it is duly provided, my lord. I have forgotten to say this citation. It has been duly provided for everyone.
You should know that if you are relying on any law and you want the court to go with you, you have the law report with you, or you refer the court to the online page letting all the costs come out.
Duly noted, my lord. I apologize for that.
Continue.
Most of my lord. My lord, the defendant does submit that the reward he held in favor of the defendant based on lack of proper judicial procedure, my lord. My lord, may I proceed to you?
Yes.
My lord, to properly elaborate on this issue, my lord, the defendant will be arguing from two major standpoints. The first is whether Chief Arrest is guilty of the offense of classification, my lord. The defendant, my lord, actualized. Whether the defendant is guilty of unlawful transaction under in violation of the Money Laundering Act, my lord.
Yes.
My lord, so the first major standpoint, which is classification, I would like to adopt the definition of Black's Law Dictionary 11th edition. Which defines classification as a compensation or reward for a service or benefit. My lord, the court in Moot against states, citation duly provided. My lord, may I read the citation, my lord?
Yes.
2019-16 Nigerian Weekly Law Reports, Part 1380, page 207 and page 235, my lord.
Yes.
Most obliged, my lord. My lord, in this case, the learned justice established 3 elements to be proved for the offense of classification. My lord, he states that the defendant must have corruptly accepted gifts from an individual or group of individuals. My lord, it also states that the gifts were accepted in performance of his official acts. My lord, to the third issue, it also stated that the gifts were accepted as an inducement or reward for doing, bearing to do, or refusing to do, my lord. My lord, this was also adopted by the Federal Republic of Nigeria, by the learned justice in the case of Federal Republic of Nigeria against Al-Khalid Mohammed. Citation will be provided, my lord.
Yes.
My lord, it is straight law that the prosecution is required not to prove one of these elements, not to prove 2 of these elements, but to prove 3 of these elements, my lord. Notably, my lord, the defendant indeed received a gift of presidential value from Axon multinational oil companies. However, this was not in contravention of the Section 19 of the Conduct Practices and Other Related Offences Act, my lord, as it was merely based on free will. My lord, Axon did not specify any gift reward expected from the expected from the defendant, and the defendant did not specify anything that he was going to do him, my lord. This is evidence with the letter of permission written by Axon multinational company sent to the president, and the president replied to him. My lord, this has been duly provided in this case as an evidence. May I proceed, my lord?
As an evidence or exhibit?
Exhibit, my lord.
Exhibit what?
Exhibit X, my lord, which is exhibit 10, my lord. Exhibit 10, my lord.
Yes.
Most obliged, my lord. My lord, based on this, the defendant can confidently affirm that the first element was not proved in any way. Furthermore, the defendant asserts that the gift was not in forbearance of something done, something to be done, or something omitted to be done. My lord, on the second standpoint, on whether the defendant can be held liable for unlawful transaction in contravention of the Money Laundering Prohibition and Prevention and Prohibition Act, my lord, the defendant asserts that the defendant strongly denies the allegation of giving the cash of 50 million naira to each of his party delegates, my lord. My lord, these allegations are so distorted. Section 2 of the Money Laundering Prohibition and Prevention Act provides for the limitation of cash withdrawal per day.
Sorry, counsel, I've looked at the issue of presidential library. So,
yes, my lord. When it was
on 50 million.
Yes, my lord. I concluded it not quite long, my lord. I stated that, furthermore, the defendant asserts that the gift was not in forbearance of something done, something to be done, or something omitted to be done.
Now,
Upon this argument, my lord, the seek indulgence from this court to give me just a minute to quickly round off my
Yes, 60 seconds. Start now.
What about my lord? My lord, this obligation are distorted. Section 2 of the Money Laundering Prohibition and Prevention Act provides for the utilization of cash withdrawal per day. In a case where such occurs, the financial institution has the duty to report any unregulated transaction. This is not stipulated under the Section 7 of the Money Laundering Prohibition and Prevention Act, my lord. The claim is unreasonable, as the defendants could not have withdrawn such amounts from any financial institution in Nigeria. My lord, the prosecution has failed to look at as an inquiry was alleged to carry out this act. No financial institution deemed it fit to report such unregulated transaction. My lord, it is important to note that with no evidence tendered and none of these bank financial institutions coming forward, my lord, this claim is clearly based on assumption and should not be considered by this court of law. My lord, what the prosecutor might want to argue that the financial institution is obligated.
Yes.
Much of that, my lord.
Thank you. We have a seat.
Thank you very much, my lord. My lord, once again, BD Odukale is my name, and I will be enunciating on the third issue, my lord. The third issue states, my lord, whether the defendant can be held criminally responsible for Mr. Ayeku Oto's disappearance. My lord, to this question, the defendant answers in the negative, firmly contending that the defendant cannot be criminally responsible for the disappearance of Mr. Ayeku Oto. My lord, to begin with, evidential body refers to a party's duty in a legal proceeding to present evidence that supports a claim or defense and raises an issue for the court's consideration. My lord, according to Section 135 of the Evidence Act 2011, it states, my lord, if the commission of a crime by a party to any proceeding is directly in issue in any civil or criminal matter, it must be proved beyond reasonable doubt. This was also enunciated in the...
So this is contained in your memorial?
Yes.
Then I don't pray.
My lord, as I said, my lord, according to Section 135 of the Evidence Act, it states that the standard of proof is proved beyond reasonable doubt. And this has also been enunciated in the case of Nasiru Mohammed versus the state. My lord, citation is duly given in that's Court of Appeal. Court of Appeal.
What is your submission? Your submission.
My submission, my lord, is that the prosecution have not actually satisfied the standard of proof that has been levied on them by the law, my lord. Moving forward, my lord, in this case, the prosecution has failed to present credible evidence linking the defendant to the deceased or the alleged deceased disappearance, my lord. It must be noted that under our criminal system, my lord, that an accused person is presumed innocent until proven guilty, as enunciated in Section 36, Subsection 5 of the Constitution of the Federal Republic of Nigeria. My lord, and also plethora of cases such as Okutu, Obiode, and others versus the state, my lord. My lord, we are also enunciating that the defendant is actually proven guilty when he is innocent, my lord. My lord, in this present case, the prosecution has adduced no iota of evidence, my lord, whether in the form of an eyewitness, neither have they provided any police reports, my lord, and also they have not provided any forensic linking that shows a causal link between the action, that is the actor's views of the defendant, and the mens rea, my lord, that is they don't show the intention, neither have they shown the action of the defendant, stating that he was the one that caused the disappearance of Mr. Ayeku Oto, my lord. Disappearance of the deceased. My lord, this is a witch hunt, my lord. My lord, and also, my lord, Lord, we are assuming but not conceding that the prosecution invokes the last seen principle, because according to the evidence that was given to us, they stated that the disappeared person is dead. My Lord, before the last seen principle can be applicable in any case, there must be a circumstantial evidence that actually shows that the accused, that is the defendant, was seen with the disease before his death, my Lord. And this has been stated in the case of State versus Bafel Ifeosoni, citation 2009 Supreme Court, point 33, my Lord. My Lord,
the doctrine of last sin is not applicable in this case?
Yes, my Lord, it is not applicable, my Lord, in any way whatsoever, my Lord.
Yes.
My Lord, and the defense counsel will actually state, my Lord, that the prosecution has failed to satisfy the burden of proof that has been stated, the standard of proof that has been stated in law. Neither have they proved any element, my Lord. They have not proved any element of any crime before this court, my Lord. My Lord, the defense counsel would love to take leave of court to say our conclusions and prayers, my Lord.
You have just 60 seconds to.
Thank you very much, my Lord. I'll stop this. My Lord, in summary, the defendant submits that the prosecution has failed to prove any allegation against the defendant. The late asset declaration is not a constitutional violation, especially in the absence of having evidence of non-compliance or misuse of foreign accounts, and falls within the exclusive jurisdiction of the Code of Conduct Tribunal. Allegations of classification and money laundering lack support, as no corruption intent or lawful transaction were established. Finally, my Lord, the claim regarding Mr. Ayekoto's disappearance is purely speculative, my Lord, with no credible link to the defendant. My Lord, consequently, the defendant respectfully prays this honorable court to dismiss all charges against the defendant for lack of credible evidence and failure to prove beyond reasonable doubt. Strike out issue 1 for want of jurisdiction, or that the special panel appointed by the current president failed to conduct thorough, fair, and impartial investigation. Thank you very much, my Lord.
Thank you. Prosecution.
With profound humility to this honorable court,
You have 10 minutes.
I remain J.I. Adeyemi.
Yes.
My Lord, before we delve deep into our deliberation, we would like to draw the attention of this court to the admission or reliability of every document signed by the defendant. My Lord, there is an apparent conflict between the very first document on the list of evidence provided by the defendant. There is a conflict in the signature, which is apparent enough and clear to this honorable court. My Lord, in view of this, pursuant to section 93, 94, and 101 of the Evidence Act, the prosecution contends that the authenticity of this document is in question, and as such, it cannot be relied upon without credible evidence verifying the signature. We urge this honorable court to either reject the document or discountenance its probative value as laid down in the notorious case.
Which evidence are you referring to?
My Lord, the letter of acceptance and location of presidential library. My Lord, I'd like this honorable court to compare the signature, which was the alleged signature of the defendant, to other documents signed by the defendant.
They work in tandem, my Lord.
Yeah.
Yes, my Lord. So, my Lord, there is an error in the point of fact. They stated that they falsified.
Cannot re-argue your case, only address the court on point of law.
Yes, my Lord. And my Lord, on point of law, it has been enunciated in section 135 of the Constitution of the Federal Republic of Nigeria that the president is not in office for life. That is, he has successors that actually come in, they swear the oath of office, my Lord. And my Lord, it has been clear, or the gratification matter, my Lord, that the gratification was given to the office of the president and not to the defendant personally, my Lord. My Lord, the office of the president is similar to a corporate soul, my Lord. The individual that is in the office is different from the office itself, because when his tenure ends, another successor comes into office, my Lord. My Lord, what we are trying to rely on by stating this is the fact that the library that was given as a gratification was given to the office of the president, and it was tagged the presidential library and not Chief Arrest library. My Lord, moving forward, my Lord, now, my Lord, we are stating that the evidence that was given before this court concerning the meeting statements on oath, my Lord, does not show or enunciate any ID card or whatsoever of the people that were stated in that evidence, my Lord.
Yes.
My Lord, we cannot really verify who these persons are, my Lord. Anybody can go to the cyber cafe to print out a particular written statement on oath, my Lord. There is nothing that shows the identification of these people, my Lord. My Lord, before witnesses can actually appear before the court, my Lord, there is a clear rule that their names are stated, their ID card are stated. We know who these people are, my Lord. These people, we don't know them. And the prosecution counsel stated that 17 people were given 50 million naira. My Lord, they only stated 4 people's written statement on oath, my Lord. What about the remaining 13 people? Are they assuming that because of 4 people stated certain facts or whatever, are they assuming that, my Lord, are they assuming that the remaining 13 people actually did the same thing? There is no evidence to prove that fact, my Lord. And lastly, my Lord, on the issue of the disappearance of Mr. Ayeko, my Lord, my Lord, it has been enunciated in the case of Moot versus the state, my Lord. Citation is 2013, my Lord. Part 1360 page 12.
The case of between Attorney General Organization of Amango Republic and Chief Arrest Akwayi.
Before we do this course, I am P8 currently. I was appearing with me to my co-counsel, TF Ajay. Our humble appearance in the prosecution in this case.
My Lord, I'll take issue 1, issue 2, and issue 4. While my co-counsel will address the court on issue 3 and issue 5. Before my emphasis on before assuming position, a of maintenance and operation was clearly interpreted. The court held that maintenance and operation means having control or carrying out transaction during tenure. My God, it is the foundation of the defendant that the literal rule and the literal meaning of the law must be carried out, and we must not read meaning to the law what is not there. My God, it's also of the defendant that the law did not say fail to close or own or possess before as a new person. It said during tenure. My God, such a thing not get hold of evidence that states that whoever asserts a fact to be true must prove that that fact exists, my Lord. My Lord, if the prosecution claims that he carried out transaction during his tenure, my Lord, it is for them to prove that fact beyond reasonable doubt, as stated in section 135 of 1 of the Evidence Act. My Lord, in the same case of Saraki, the State Republic of Nigeria, the court held that for a prosecution to prove that a party carried out transactions, they must prove active involvement. My Lord, emphasis on active involvement. They must show that the defendant carried out transaction during that tenure. My Lord, is the condition of the defendant that the defendant should not be tried and the judge should be protected and should not be tried actively for a crime that does not constitute an offense that the crime was carried out, my Lord. My Lord, this is clearly stipulated in section 36 sub 8 and also section 36 sub 4, which is a fundamental right of the defendant as clearly protected under the Constitution. My Lord, section 36 sub 8 says that no one shall be held guilty of an offense or an act or omission that did not constitute a crime at the time it was carried out. My Lord, section 36 sub 12 states that no one shall be guilty of a crime which is not prescribed in a written law. My Lord, it's also the defendant that the defendant should be tried for having a foreign account before assuming position. My Lord, the defendant declared his asset, and if the prosecution believes that he did not declare his asset, they should be want to prove that they want to lay it out. And my last issue for today, before my co-counsel address the court of issue 3 and issue 5, is issue 4. With borders on constitutional immunity, procedural lapses and defense, and constitutional and the fundamental rights of the defendants. Under this issue, I'm going to be highlighting 4 points. The first one is constitutional immunity. The second one is condition precedent. The third one is jurisdiction. And the last one is fundamental rights. My Lord, section 308 sub 2 of the Constitution clearly states that subsection 1 shall not apply to a public officer if he carried out this act in his official capacity or he is being tried as a nominal party. My Lord, in the case of FRM responsibility 2006 case, the court held that duties of a public official falls within his official capacity. Likewise, any breach or allegation of breach falls under that same line. It's our foundation that the defendant has immunity. But let's assume that it doesn't have immunity. But in the case of power invest IGP, the court held that investigation can be carried out. My Lord, the prosecution delayed. My Lord, I would highlighted that the report, the special report, is ultra-biased. But let's assume it's not ultra-biased. The delay in carrying out the strict procedure. My Lord, as I mentioned earlier, section 3D of the Code of Conduct states that investigation shall be carried out by the Code of Conduct Review, which was stipulated in the case of Saraki vs. FRM by the Supreme Court. My Lord, in the case of Bonmari vs. Bonmari, the court held that condition precedent is a prerequisite that must be followed before a court can assume jurisdiction. My Lord, moving on to jurisdiction, it is in the logos practice of multiple logos in Kennedy. The court held that there are 5 requirements for a court assume jurisdiction. My Lord, one of them is due process of law. My Lord, when the process of law is not carried out, the court cannot carry out jurisdiction on that case. My Lord, we cannot discussion of defendant that if the prosecution wanted to get that within their power to do so, if they wanted to carry out jurisdiction or sue my client, they should have followed the due process of law. My Lord, unless the process of law is followed, my client cannot be tried.
Respectfully, my Lord, I shall be addressing the court on issues 3 and issue 5. If it pleases this honorable court, I shall continue to my meeting. Thank you, my Lord. My Lord, issue 3 has been consciously crafted for the court to determine the question as to whether or not the acceptance of the gift of public library constitutes gratification under relevant law. My Lord, it is our humble submission in this case that the acceptance of the public library does not in any way whatsoever constitute gratification under sections 2 and sections 8 of the Corruption and Related Offences Act 2000, section 10, subsection 3 of the Code of Conduct Bureau and Tribunal Act, and paragraph 6, subparagraph 3 of the 5th schedule of the 1999 Constitution of the Federal Republic of Mango. My Lord, to start with, Section 2 of the Corrupt Practices and Related Offences Act defines what constitutes gratification, and I paraphrase, that a gift shall constitute gratification if it is given with the intent to influence the performance or non-performance of a public duty by a public officer. Additionally, my Lord, Section 8 provides that where the public officer receives the gift corruptly, and it is in such case that it will constitute gratification. However, my Lord, this therefore shows that there are two conditions that must be proven. One, that it was given with the intent to influence the performance or non-performance of the public duty, and two, that it was received corruptly. My Lord, these two conditions are not be proven in this case, and therefore it cannot be shown that my client, Chief Alec Abaye, has accepted the gift as gratification. My Lord, it is also important to note that these provisions have been recognized under paragraph 6, paragraph 3 of the 5th schedule of the Constitution of the Federal Republic of Mango. And I seek the leave of this honorable court to read the provisions of this paragraph. My Lord, the proviso of this section expressly says that, accordingly, the mere acceptance or receipt of any such gift shall not be treated as a contravention of this provision. My Lord, this provision is also contained word for word under section 10, subsection 3 of the Code of Conduct Bureau and Tribunal Act. My Lord, the provisions of these sections are clear and unambiguous, and as noted by the court in the case of INEC versus General Muhammadu Buhari, where the provisions of the statute is clear and unambiguous, it must be interpreted literally and its ordinary grammatical sense. My Lord, we therefore call this honorable court to interpret the provisions of this section in its ordinary grammatical sense. This is no wonder the reason of calling in the case of Federal Republic of Nigeria versus Dairo citation which provided, my Lord, has held that the mere acceptance of a gift by a public officer does not in any way constitute a gratification if there is no corrupt intent. My Lord, I shall be moving to issue 5, which, my Lord, this issue has been consciously crafted for the court to determine whether or not there is an evidential body linking the disappearance of one Mr. Ali Oto to Chief Abaye. My Lord, it is a humble submission before this honorable court that there is no piece of evidence linking the disappearance of the man to the chief, and that if there is any evidence, the body lies on prosecution to prove. It is important to note that by virtue of section 36 or section 5 of the Constitution, every accused person shall be deemed innocent until proven guilty. This is known as the principle of presumption of innocence, my Lord. And it is important to note that this duty falls on the prosecution. My Lord, as noted on this duty on the prosecution is recognized under section 131 and 132 of the Evidence Act. Specifically, section 131 provides that who asserts shall be affirmative negative which probatio, my Lord. This therefore shows that the body is on the accused, my Lord. Also, section 132 provides that the body is on the person who shall fail if no evidence is adduced in the trial. My Lord, this is obviously the prosecution. The prosecution is the person that will fail if no evidence is adduced in the trial. Thus, the body lies with them. Also, it is important to know that the standard of proof in this case is beyond reasonable doubt. My Lord, we are recognized under section 135 of the Evidence Act. My Lord, if the prosecution does not prove beyond reasonable doubt, my client cannot be guilty for the disappearance of Mr. Ayekoto. It is also important to note, my Lord, that the main fact that Mr. Ayekoto disappeared on the day he was invited to the villa is not in any way an evidence that the chief is responsible for such disappearance. My Lord, that is merely circumstantial evidence. And as noted by the court in the case of Okoro versus State, citation is being provided, my Lord. For circumstantial evidence to be admitted by the court, it must be coherent, clear, and it must be unequivocal, my Lord. My Lord, these conditions have not been proven or shown in any way in this case. I would therefore call the court to dismiss in totality the case for prosecution and uphold the innocence of my client's innocence. Thank you, my lord.
Respectfully, my lord, the case before this honorable court is one that borders on allegations that were levied against one chief, Aaron Abraham. My lord, all due processes culminating upwards to this moment has been followed and subject to the convenience of the court. Seek the court to proceed with our final review. All citations are being provided by the argument. However, in the case of how it was Inspector General of Police, the court of the opinion that the immunity clause only lasts up until the moment that the individual occupying the office leaves the office, and the inspiration we derive from this is that once an individual leaves the office, he is no longer covered with the law of immunity clause as provided by the law. And my lord, when the wordings of the statute are clear and unambiguous, it is only fitting that the literal law interpretation be taken to apply in that sense. And my lord, the provisions of section 308 sub 3, section 308 sub 1, they are both clear and unambiguous. Because a cumulative reading of it reflects that the ex-president is no longer in the official capacity to be covered with the law of immunity clause. And my lord, this has been given judicial blessings in the case of Excel Plastic versus MBN provided, as well as Chief of Naval Staff, Battleship versus Chief of Naval Staff, citation is provided as well. That is our submission with respect to this issue that Chief Ariel, by no longer occupies the position of authority, he is no longer the president, and proper civil and criminal proceedings can follow thereof. Or in light of the argument can lost with respect to this issue, we only submit that Chief Ariel Agbaye can be prosecuted. We pray this court will say. On the basis of the second issue, which borders on whether the operation of pre-existing foreign bank accounts constitutes a constitutional violation. And also, the prosecution respectfully submits that the existence of and the operation of this bank account constitutes a constitutional violation. But in canvassing our standpoint, we will be addressing this argument from two ways. Number one, that he failed to declare his assets, and secondly, that he maintained and operated foreign bank account while he was in office. Now, with respect to whether he maintained and operated foreign bank account while he was in office, we respond in the affirmative. Now, the provision of paragraph 3 of part 1 to the 5th to the 5th schedule of the 1999 Constitution is clear and indisputable. Now, it clearly provides that public officers, one of which the president is, are prohibited from operating foreign bank accounts. Now, this has also been reinforced by virtue of section 7 of the Code of Conduct Bureau and Tribunal Act. Now, the Code of Conduct Bureau and Tribunal Act is applicable pursuant to section 172 of the 1999 Constitution of the Federal Republic of Nigeria, which ensures that compliance are expected to be made with. Now, in that sense, it is immaterial if the president has opened the account before he got into office. What is important to note is whether he operated this account while he was in office. And my lord, incorporating this, we have tendered monetary report, bank financial statement that he operated this account in 3 distinct countries, in Switzerland, in New York, and in Cayman Islands. And all of these are already been presented to the court, and it's also further corroborated by this witness statement of oath of the bank manager, supporting the validity and efficacy of the document. Now, furthermore, on the subject of whether he failed to declare his assets, or the provision of section 140 of the 1999 Constitution is of the foreign bank account represents the constitutional view and represents the infraction of the law. And secondly, the failure of the president to declare his assets as required by law also constitutes a constitutional breach. My lord, the opposite counsel in canvassing made mention of a panel that was set up. My lord, it is worthy of note that this panel in no way possesses any capacity to prosecute. The panel was only set up for investigation, and in that sense, it does not prosecute. All proper due process has been followed up until this moment, the Code of Conduct Tribunal, and everything has been strictly adhered to. But the provision of section 5 of the 1999 Constitution is instructive in this sense. It imposes a requirement on the President, the Executive General, to maintain and execute the provision of the Constitution. And my lord, this is only in line with it. And not hence, reliance on all the authority of them or name of domestic counsel is misguided and not applicable in the state. As nobody sits on the case, it is only an investigative duty and it is only carried out by the President. should not be taken to be applicable in this case. And in light of the arguments and last respect to these two issues, I expect to submit that the President's operation of the foreign bank account, as well as his failure to declare his assets, represents grave infractions of the law, and the President is not superior to the law, hence he should be met with the strict sanctions as provided by the law. By the source of it, and we pray this very report all the same in the true. Subject to the competence of the court, I seek the provisionary report to defer the floor to my co-counsel to take on the third and the fourth issue, respectively.
Alright, thank you. Respectfully, my Lord, the third issue for determination is whether the evidence against Chief Are is sufficient to sustain criminal charges without infringing on his rights to fair trial. Well, in furtherance of this, we shall place reliance on two major standpoints. The first of which is all evidence that are due to the report have passed the primary test of sufficiency, and the second one which is the prosecution has complied with all constitutional provisions that are providing for the fair trial rights of the accused. My Lord, in respect to the first standpoint, we shall contain our agreement on four major points. Well, the first of which is the failure to declare assets by the President as if there was Chief Are, and this is in contravention of Section 140 of the Constitution and also Section 15 of the Code of Conduct Bureau and Tribunal Act. And my Lord, also the maintenance of foreign bank operations in New York, Cayman Islands, and Switzerland also constitute a grave contravention of Section 3, paragraph 1 of the 5th schedule 1999 Constitution. And my Lord, in light of this argument, we have tendered evidence of a bank statement of account with the three financial institutions and also a written statement of both deposing to the validity of this bank statement of account. But on the second charge, which is the gratification that was received from Amazon. My Lord, also, thank you, most grateful, my Lord. My Lord, on the second round, which is the obtainment of gratification from Amazon Multinational Oil Company. My Lord, as to this, we have also tendered evidence of the deed of donation that was received by Chief Are, and my Lord, we also contend that this is a grave criminal offense under Section 8 of 1 of the Independent Corrupt Practices and Other Related Offences Act that states that any person who corruptly obtains or receives any form of gratification is liable to 7 years imprisonment and also is also liable for offense called official corruption. Now, on the third ground, which is the receiving of withdrawal sum of 50 million cash sum from a bank to give party delegates who accepted his proposal to make him president for life. Now, on this, we submit that Chief Are has contravened Section 19 sub 1D and Section 19 sub 2D of the Money Laundering Prevention and Prohibition Act that state that nobody will withdraw a cash sum of more than 5 million naira, my Lord. And as to this, we have tendered a written statement of both of one Chief Ajani Adebayo, who has deposed to have received that 50 million cash sum, my Lord. But on the last charge, which is that Chief Are has caused the disappearance of a vocal critic of his, who is known as one Mr. Ayekoto. Well, the prosecution will establish the nexus between the invitation and the disappearance of this Ayekoto by tendering evidence of a CCTV footage that saw him at the presidential villa that night, and not only this, also of a WhatsApp message between him and his wife and my Lord, court has received this as exhibit. My Lord, on this first standpoint, we submit that the prosecution has tendered evidence that have passed the primary test of sufficiency. My Lord, on the second standpoint, we also submit this honorable report that the prosecution has in no way infringed on the fair trial right of the accused. My Lord, we shall submit this on 5N, the first of which is that all the charges that have been brought against the accused are defined under the laws of Mango, which are in pari with the laws of Nigeria. My Lord, and this is subject to Section 36 of 12 of the 1999 Constitution. The second of which is all evidences that have been brought before the statutory authority, and our arguments have been covered that the prosecution has passed all parameters of sufficiency and has in no way infringed on the federal right of the accused. And my Lord, also, we also affirm the guilt of the accused, and we pray that this court votes in favor of the prosecution. My Lord, on the first issue, which states that whether the prosecution has met the evidentiary body, a lady is accused. So the disappearance of one Mr. Ayekoto, my Lord, the prosecution firmly contends that the disappearance of Mr. Ayekoto, a vocal critic of Chief Are's governance, is on Chief Are Agbaye. My Lord, the prosecution will establish the nexus between the invitation and the disappearance of this Chief Are Agbaye by telling a very valid form of evidence, chosen as circumstantial evidence. My Lord, the prosecution will canvass its argument on three major standpoints. One of which is motive, the second one opportunity, and the third one control. My Lord, on the point of motive, the point is on that Chief Are Agbaye had every form of motive to cause the disappearance of Mr. Ayekoto. My Lord, this is not a motive, it is the driving force behind something. My Lord, in the Supreme case of Daniel Majemu versus State, the court have held that while motive may not be a necessity in proving the guilt of an accused, it is also important to note that when it is extent in any case, it must be taken as proof and a detection to guilt. My Lord, also in the case of Daniel versus State, section provided in our brief of argument, the court have held that motive can be used to infer guilt on the accused. My Lord, we have to submit on the position of law that because the accused had every form of motive to cause the disappearance of Chief Agbaye. My Lord, on the second note, which is opportunity, we firmly affirm that Chief Agbaye had every cause of opportunity to cause the disappearance of Mr. Ayekoto. My Lord, it is important to know that it is the president that has the sole and full control over the presidential villa. My Lord, we have tendered evidence of a CCTV footage that shows that Mr. Ayekoto was in the presidential villa that night. And my Lord, in view of this, we also submit that Mr. Agbaye had every form of opportunity to cause the disappearance of this Mr. Ayekoto. But the third point, which is control, but the constitution submit that the accused had every form of control over Mr. Ayekoto to cause his disappearance. But in section 140 of one of the evidence act, it has been stated that when specific facts are in the knowledge of an accused, he must prove them. But also in the case of Okoro versus State, the court have held that the silence of an accused can be used to have guilt on the accused. But the accused has not mentioned anything and has refused to deny or even affirm this allegation against him, which is proving him guilty. But we only submit for this honorable court that the accused had every form of motive, opportunity, and control to cause the disappearance of Mr. Ayekoto. But why it is important to note that section 135 of the evidence act clearly states that when there is a commission of an offence by any party in any proceeding, the commission of that offence is directly an issue, and it must be proven beyond reasonable. It is important to note that also the court in Stanley versus Agbaye, the Supreme Court case, also held that it does not mean it should be proven beyond every shadow of doubt. But we firmly submit on the virtue of our argument that we have as judicial authority and statutory authority that the disappearance of Mr. Ayekoto was caused by Chief Are Agbaye, and we pray and urge this court to also say in favor of the prosecution. If it pleases this court, I seek the leave to read my prayers. Most gracious my Lord. I was flowing from the above canvas argument. We hereby pray that this court grants the following relief: that the immunity provided under section 3A of the Constitution does not shield the defendants posted on. We also declare that the defendants continued operations of foreign bank accounts while in office
Mr. Fatimo, you'll be reacting.
Yes, ma'am.
Your defense. Alright, so proceed to.
My Lord, I respectfully rise to refute certain assertions made by the prosecution in this case. My Lord, it is important to note that the submissions of the prosecution in this case are riddled with constitutional misinterpretation, evidential doubts, and procedural irregularities. It is important to know that justice must not be served on the basis of assumption or illusion, but on the basis of strict adherence to the law and clear evidence. My Lord, the prosecution in this case has argued that the existence of a foreign account before the assumption of office and the fact that the President has failed to declare his or close the account during his tenure in office constitute a breach. However, my Lord, I will refer the court to the provisions of paragraph 6 of the 5th schedule of the 1999 Constitution of the Federal Republic of Congo. The provision of this section prohibits active operation of account during tenure of office and not mere existence of the account, my Lord. My Lord, the prosecution in this case has failed to show that the President was in active operation of the account during his tenure in office. My Lord, and I urge this honorable court to dismiss in totality and refuse to admit in evidence the statement of account adduced by the prosecution in this case on certain grounds. One, my Lord, the statement of account is an electronically generated evidence, and the prosecution has failed to comply with the provision of section 84 of the Evidence Act, which provides that a certificate of compliance must accompany an electronically generated evidence. So, number two, my Lord, the evidence should be rejected on the ground that there are inconsistencies in the statement of account. For instance, my Lord, the supposed statement of account from the Bank of Cayman Island contains the date of June 2025 to August 2025. My Lord, these are future dates. The President in this case is a former President. How can future statement of account be adduced to prove the date of when he was in office in the past? My Lord, on this basis, I urge the court to reject them. Also, the statement of the supposed banker of Cayman Island should be rejected on two grounds, my Lord. First, my Lord, section 177 of the evidence states that before an officer of a bank or a banker can give evidence in a trial in which the bank is not a party, an order of report must be brought to that effect. But no such order is presented by the prosecution in this case, my Lord. Also, by virtue of paragraph 4 of that statement, the banker himself stated that the statement of account given content was gotten from January 1, 2023 to December 31, 2023. But the statement of account itself states June 2025 to August 2025. My Lord, these are obvious contradictions and irregularities, and it is the position of the case of Moot versus Godolphin, citation duly provided, my Lord. Citation 1978 for SC 91. Because of that, where there are obvious contradictions, it is a ground for the court to disbelieve the case and to reject the evidence, my Lord. Also, my Lord, the prosecution in this case has stated that the mere receipt of public library constitutes gratification. However, my Lord, they have failed to prove the relevant conditions to be recognized under section 2 and section 8 of the Corrupt Practices and Related Offences Act. These conditions are that one, the gift was given with the intent to influence the performance or non-performance of the public duty, and two, that it was received corruptly. My Lord, these conditions were not proven in this case, and as a result, we got to hold that the prosecution has not proven this case with those people. Additionally, my Lord, the deed of donation given by the prosecution in this case should be rejected and not admitted in evidence. My Lord, a deed by its very nation must be signed, sealed, and delivered as held by the court in the case of Ogunba versus Abuaba. However, my Lord, in this case, this deed was only signed. It was not sealed, it was not even delivered in the first place. This which means for me that it is not even valid. The gift in the first place is not valid. Why should my client be held liable on the ground of an invalid gift, like a gift that is invalid admission? My Lord, I also refer the court to the provision of section 95 of the Evidence Act, which also recognizes the evidence with regards to the document that must be sealed and delivered. Finally, my Lord, the prosecution has failed to give substantial evidence as to the disappearance of Mr. Ayuboto in this case. My Lord, the prosecution in this case noted and argued that by the CCTV footage they provided, that the evidential body on them has been proven beyond reasonable. However, my Lord, I would like the court to note that in the first place, it's not even admissible because it is an electronically generated evidence, and no certificate of compliance was given in breach of section 84 of the Evidence Act. And second, my Lord, if you examines the CCTV, it mainly shows the image of a house. How can the image of a house link the chief to the disappearance of the accused in this case? Now, these are mere circumstantial evidence, and as noted by the court in the case of Okoro versus State, as noted by the case of Okoro versus circumstantial evidence must be both equivocal and complete. My lord, the defendants in this case have not proved this. Thank you, my lord.
My Lord, this case has been decided for judgment.
Yes. Now, judgment. This is a case involving allegations of corrupt practices and related offences brought against the defendant, Chikari, the former president of Mango Republic. He is charged with the following offences. 1. Failure to discharge his assets during his tenure as president, contrary to the code of conduct of Act. 2. Operating and maintaining foreign bank accounts in Switzerland, New York, and the Cayman Islands, contrary to Section 6 of the 5th Schedule to the Mango Republic Constitution. 3. Accepting ratification of the foreign presidential library from Axon Multinational Oil Company, contrary to the Independent Corrupt Practices and Other Related Offences Act. 4. Giving a cash sum of 50 million to each of his party delegates who supported his proposal to become president for life, contrary to the Money Laundering Act. And 5. The disappearance of Mr. Ayekoto, a vocal critic of the defendant, contrary to the Mango Republic Criminal Code. Now, the prosecution, in support of its case, the prosecution said that 12 exhibits, exhibits B1 to 12. Now, on the 30th of May 2025, prosecution filed its memorial and submitted 5 issues for determination. I'm going to skip the issues as submitted by counsel, by the prosecution counsel. Now, it must be noted that the defendant filed no memorial in this matter. Now, I'll go straight to the findings of the court. Now, the sole issue before this court is whether the prosecution has discharged the body of proof based upon it by law in establishing the guilt of the accused in all the offences charged. The body of proof in criminal cases lies squarely on the prosecution. An accused is presumed innocent until proven guilty beyond reasonable doubt. See the provisions of Section 36(5) of the 1999 Constitution and the case of Bayoku versus State, citation supplied. Now, on the failure of the defendant to declare his assets, the prosecution is required to prove that the accused failed to declare his assets before assuming office and throughout his tenure. Exhibits P1, P2, and P3 clearly establishes that the accused was reminded to comply and failed to do so within the time required. Accordingly, I find the prosecution has established this offense beyond reasonable doubt.
beyond reasonable doubt. And I want to say that immunity, the defense of immunity, does not avail him. Now, on the second offense, that is offense of operating foreign bank accounts, Exhibits B4 and B5 reveals that they are accused to maintain active accounts in Switzerland, New York, and the Cayman Islands between June 2015 and February 2023 during his presidency. The Constitution expressly prohibits a public officer from maintaining foreign accounts. I therefore find him guilty of the second offense. Now, on the offense of acceptance of gratification for the presidential line, the prosecution was proved that the accused received donations for the presidential line from Axon Multinational Oil Company as an inducement or reward in connection with his official duties, particularly regarding oversight of the petroleum ministry. Now, Exhibit B7 merely indicates that the accused oversaw the Ministry of Petroleum. Exhibit B9 shows that the accused incorporated the Presidential Library Trust. Exhibit B8 is an internal memorandum of acts of multinationals, but it is not supported the proof that the sum of 2.5 billion was remitted to the account of the accused person. I attach no probative value to Exhibit B6, which is an opinion of a writer in a newspaper publication, particularly when the writer was not called in evidence to test the veracity of his writing under cross-examination. Now, suspicion, however strong, cannot take the place of legal proof. See the case of Baju versus FRA, citation supplied. In view of this, I do not find the defendant guilty on the third count. Now, on the fourth count of money laundering, the prosecution fails to tender any evidence showing the payment of 50 million to party delegates, or that any person received such a sum from the defendant. Without credible proof, the court cannot convict. I do not find the defendant guilty. Now, on the last count, which is the disappearance of Mr. Ayeko, the prosecution relied on circumstantial evidence and the doctrine of last seen, as there is no direct evidence or confessional statement in this case, tying the accused to Mr. Ayeko's disappearance. Now, the prosecution has placed before this court proof that Mr. Ayeko is a victim of the accused. This is evidenced by Exhibit B2, which showcases Ayeko's critical publication of the accused. Now, the prosecution also tendered security logs at the villa Exhibit B10, showing only Ayeko's entry and no exits on the 12th of June 2021. Last month, the prosecution tendered a CCTV footage report showing malfunction of the CCTV at the presidential villa on the 12th of June 2021. It must be stated that the report showed that the footage gap was not caused by technical malfunction. In my view, the prosecution has discharged the legal body in establishing this count. Now, the doctrine of last seen places a duty on the accused to explain the whereabouts of a person last seen in their home. The defendant has failed to do so. In this case, the law is settled that for a court to validly convict on circumstantial evidence, such must point irresistibly to the accused person as the only person who committed the offense. See the case of Adequate versus State. Citation supplied. The evidence points irresistibly that Ayeko was in company of the defendant on the 12th day of June 2024, and we cannot account for the whereabouts of Ayeko. I find the defendant guilty on this count. Now, having reviewed the totality of the evidence before the court, I make the following pronouncements. On count 1, I find the defendant guilty. On count 2, the defendant is found guilty. On count 3, the defendant is found not guilty. On count 4, he is found not guilty. And on count 5, he is found guilty. Now, the defendant, Chief Abila Gaye, is hereby convicted on counts 1, 2, and 3, and is acquitted on counts 3 and 4. Sentencing is adjourned to a later date to allow the accused to make representation as to mitigation and for the court to consider his allegations. I think that's the end of the whole thing. Counsel, this is not part of my duty, but I must commend your efforts. I'm addressing the two of you should be upstanding. I must commend your efforts, despite the fact that the defense will put out of this competition. So, I wish you success. Thank you very much. The court will rise.
My Lord, this case is at
regards the unity of the defendants, it is resolved in favor of the prosecution, the defendants, their face, posterior trial, and so on. As regards the second issue, the argument that investigations should have been carried out while the defendant was in office by the defense is dismissed. There is no limitation to investigation in this context, since it also resolved against the defense and for the prosecution. Of course, now it is also important to say that aside from these issues, the defense raised the issue of the resolution of this court. It is important to also state that this court sits at the Federal High Court. The accusation against the defendants that they operate foreign account contrary to the country code section 7 of the Code of Conduct Tribunal Act and failure to pay its assets contrary to section 15 of the Code of Conduct Tribunal Act and section 140 of the 1989 Constitution. The Supreme Court held in the case of Saraki v. Federal Republic of Nigeria, citation is supplied that where the Constitution assigns investigative powers to a specific body, such powers cannot be taken over by another. It is the Code of Conduct Tribunal, the rule, that can investigate and refer to the tribunal for determination. The Federal High Court in this context lacks jurisdiction, the charge is against the defendants before the court, and hereby struck out. As regards the issue of gratification, as rightly canvassed by the defense, the prosecution has to prove two elements. One, that the gratification, the gift was given to ensure an action or a forbearance. Two, it was also received correctly by the recipient. The meta element of corruption is inferential and circumstantial. I think that again. The meta element of corruption is inferential and circumstantial evidence, which points to the fact that the defendant, at the time of collection of the gift had the intent to take benefit of same correctly. For example, examples of the deliberate action of which the donor took benefit or a forbearance. The prosecution failed to prove that the defendants received the gift correctly. The last issue before the court is whether the defendant is culpable of the disappearance of Mr. Ayekoto's renowned party. In the case of Peter States, citation is supplied. The Supreme Court said that some circumstantial evidence are relied on by the prosecution in this instance sometimes good and better than direct evidence. In the same fact, I think that the circumstantial evidence is as good and sometimes better than any other sort of evidence. And what is meant is that there are a number of circumstances which give assert evidence a complete and unbroken chain of evidence. If established in satisfaction of the jury, it will well and properly act on scene. In the circumstances and from the evidence presented by the prosecution, there is no enough circumstantial evidence before the court from which the court can infer that the defendant is responsible for the disappearance of Mr. Ayekoto. The issue raised in this issue is resolved against the prosecution. The charge against the defendant is thereby struck out. Finally, the court denies jurisdiction with respect to issue 1 and 2, and the second issue, and then the third and fourth one, the charge against the defendant are struck out. That is the judgment of the court. Alright. Now, let me address the parties before the court. I would first of all be saying that most counsel tried on the two sides start with the first council, Miss Oladimeji and Mr. Patrick. Yes, I am very brief, very succinct, interesting too. First and want to state that I commend the efforts. Although this came as a surprise, of course, because we just notified very I enjoyed thoroughly the brief that okay. However, as a way of observation, I noticed that some of the issues raised whilst we're canvassing your arguments were in some instances mix-up. Yes, mix-up. And you know that you tried your best, but when you want to address the court, it is better you take it from a particular aspect, especially Miss I would excuse that because I know that it was a bit of anxiety trying to get things right. But in all, I saw that there was a mix-up in some instances. And I wrote them somewhere, but this came, the time I had to examine all those things. And because I've been writing so fast, I can't even do my own handwriting. Yes. For example, you raised the issue of jurisdiction as well as the act of the president being authorized. You mixed those two. It's either one or the other while you are raising the court. Those two issues are live issues, but you took them together. That is the issue. So I had to write whether jurisdiction or illegality. That was number one. Aside that, we were just a bit too fast. In the normal courts, we have to write. So, and we do not have the advantage of knowing whether the court is writing or not. Sometimes we don't drop our pen when our side is too fast. That, I think, is one out of inexperience. The time we will get there, so we don't need experience. So that is just my observation. Then Mr. Patrick, I particularly like your reply on the law, but so in some instances, step out. It's going to raise some issues of facts. Then given the scope of this proceedings, you had no liberty of seeing tender evidence, especially the prosecution. So I do not know whether you are able to raise that objection the way you did, but at least I appreciate the efforts in that regard. Thank you. Then for the prosecuting team, Mr. Oladimeji and Mr. Gayo. Oladimeji did very well too. Yes, we were fast, but not as fast as Mrs. Gayo. She was on about 200 kilometers per hour. Yes, and I love the way you articulated the points. Maybe, well, I would excuse Ms. Sajai because she has taken issues. So you took two, and those two were actually very good. Thank you for that. Ms. Sajai, I also want to appreciate your progress too. I also observed the picture of the mixture. It's not easy, and it's not easy. And I don't think it's initiating. But with too fast. they applied for a record as proceeding, and he noted the court, and she is not recorded by the court. The assumption is because I have this, because my just have this. So just take it easy, don't mix it up. Then, in those days, when he was still young at the back, we have this post-it notes, 1, 2, 3, 4. Science, yes, that's how we want to take it and the supplementary issues of that. So aside that, both hands do very, very well, just as the first thing. Thank you for your time. I wish you well, respect, and I hope that you both excel.